Hi, this is Ken Quinn, Regional Director with U.S. Term Limits. We're going to go back to the 1787 Federal Convention in Philadelphia to examine the development of the Constitution's amending provision to determine if the framers intended an Article 5 convention to be a limited convention or an open convention. On May 29th, the first working day of the Federal Convention, Charles Pinckney of South Carolina introduced a system of government which contained a very detailed amending provision. Quote, if two-thirds of the legislatures of the states apply for the same, the legislature of the United States shall call a convention for the purpose of amending the Constitution. Or should Congress, with the consent of two-thirds of each house, propose to the states amendments to the same, the agreement of two-thirds of the legislatures of the states shall be sufficient to make the said amendments part of the Constitution, unquote. Did you notice how the application had to be, quote, for the same, unquote? From the very beginning, the delegates understood this and that two-thirds of the state legislatures would need to apply for the same amendments in order to have a convention called. On August 6th, the Committee of Detail reported the first draft of the new Constitution, and the amending provision now read as follows. Quote, on the application of the legislature of two-thirds of the states in the Union for an amendment of this Constitution, the legislature of the United States shall call a convention for that purpose, unquote. Now, although the provision was shortened, it still retained from Pinckney's plan the portion which allowed the states to hold a convention to amend the Constitution if two-thirds applied for an amendment. The following month, on September 10th, the provision was debated again, and James Madison moved the following proposition. I'm only going to read the proposing section to save us some time. Quote, the legislature of the United States, whenever two-thirds of both houses shall deem necessary, or on the application of two-thirds of the legislatures of the several states, shall propose amendments to this Constitution, unquote. This motion to amend the provision passed. 5 days later, on September 15th, the delegates were reviewing the provision now designated as Article 5 for final approval. Delegate George Mason of Virginia objected to the wording because he, quote, thought the plan of amending the Constitution exceptionable and dangerous, as the proposing of amendments is in both the modes to depend in the first immediately and in the second ultimately on Congress. No amendments of the proper kind would ever be obtained by the people if the government should become oppressive, as he verily believed would be the case, unquote. Mason noticed that the wording did not reflect their intention, and he did not want to leave it up to Congress to propose the amendment applied for by two-thirds of the states. Upon this objection by Mason, a motion was made to require a convention on application of two-thirds of the states to completely remove Congress from having part of the proposing process initiated by the states. Now, although Article 5 no longer specified that the legislatures had to apply for the same, it was clearly the understanding. To demonstrate this fact, all we need to do is read the words of Madison before they voted to restore the convention mode in the provision. Mr. Madison, quote, did not see why Congress would not be as much bound to propose amendments applied for by two-thirds of the states as to call a convention on the like application, unquote. You see, Madison thought it would be unnecessary to require a convention because Congress would be bound to propose the amendments applied for by two-thirds of the states. Now, if two-thirds of the states did not specify the amendments in their application, how could Congress propose them? Obviously, Article 5 requires the states to specify the amendment or amendments they are seeking in their applications in order for a convention to be called by Congress to allow them to propose it.